أعوذ بالله من الشيطان الرجيم. Bismillahirrahmanirrahim. Assalamu alaikum and welcome to In Her Voice. I'm your host Farida Rabia Nzoki Nzinzi on the Voice of the Cape on 91.3 FM, and you don't need to miss us. You don't need to miss out. You can tune into 90.90 FM, 95.8 FM and 89.8 FM. You can also live stream us on vocfm.co.za. So today we'll be speaking about justice for survivors of gender-based violence, which is often a long process, a painful journey, not just emotionally, but also legally. While society encourages women and children to speak up, but what happens when things take time? What happens when they do, and the evidence has long faded or was never there to begin with? Today's conversation sheds light on the hidden battles survivors face in the courtroom. We are unpacking the complex legal processes around sexual assault and gender-based violence, particularly when the abuse happens over time, in silence, in secret, and there's little to no physical proof of it. Joining us to help us understand this a bit more is Junior Associate, Women's Legal Center, Andrea-Joy Yankees. It's a very big topic we are about to unpack. I would assume with, 31 years of democracy that somewhere in our legal system, when we are saying that people have rights, that it is actually executed and people are supported thereby. So understanding the legal pathways in gender-based violence and sexual assault cases, what are the first legal steps a survivor should take after disclosing abuse, especially if the abuse occurred over a long period and there's no physical evidence?
All right. To pick up from your question, I think it's important to know that you're so right in saying that sometimes specifically sexual offences cases takes so long. We've had clients that come to us and say, well, it's been 3 years in, it's been 5 years in, and it's a very disheartening process, right? So before I start with the process, I think it's just important for us to speak about some terminology.
Yes.
So that we are all on the same page, right? So I will refer to victim and survivor interchangeably, specifically in relation to a court process. The person who lays a criminal charge is the complainant in the process, where the person against whom the charge is laid is the accused, right? In our court system currently, we have the state that brings a sexual offences case on behalf of the complainant against the accused, right? So in our court system, we have an adversarial system, meaning that the other day I got a question around whether we have a jury system. We don't have a jury system in South Africa. So it's really the state versus the accused. And during that process, currently, the complainant is a witness as the person who had experienced the sexual offense, right? Really, the process starts from the reporting stage. And I think it's really important to know that for sexual assault and sexual offenses other than rape, before 2018, there was a limit to prescription. So your offense or the sexual offense would prescribe after 20 years. This means that the right to institute prosecution would be limited to 20 years. Since 2018, in a constitutional court case called Levenstein, the court then said that there is no time limit on reporting any sexual offense, and that there's no longer this period of time for sexual offenses other than rape, according to the Criminal Procedure Act, right? So I think that's the starting point to know that there are no time limits.
Okay.
The other thing that I think is really important when as a sexual when reporting a sexual offense and as a complainant wanting to go and lay a charge is that there is actually no rule that prescribes that the complainant must report the sexual offense where it happened. So say it happened in Durban, but you're currently in Cape Town, you can go to a police station, report that the incident has happened, and then the police must accept the report, and if necessary, then transfer it to the police station where the specific offense occurred, right? We call it jurisdiction, but really the crux of it is that they can transfer to where the offense occurred. What then happens is that when a complainant reports an incident, the police then registers the case in what we call the crime administrator system. So administration system. So that kind of gives you what they call a CAS number or a CAS number. You then will receive an SMS with the CAS number, and the investigation will then proceed, right? What is also really important to know is that in terms of a criminal charge that you lay at the police station, in some cases the police exercise their own discretion on whether or not to process the criminal charge, but it is important to know that they should not refuse to accept the charge. So you had spoken about cases where the abuse has happened over time or over a long period of time. When you go and you finally decide, okay, it's been a period of time, and now I'm ready to lay a criminal charge or report an incident that has happened to me, they should not refuse to accept the charge, right? When you do enter a police station, every police station should have what we call victim-friendly rooms. And really, this is where the complainant is taken away from the charge area to ensure that they are supported, they can give their statement in a safe space, because this is quite an intimate and violating experience to have to report what has happened to you. And so that's the room that they take into. And usually the statement is taken by what we call the FCS police officer. So it's a specialized officer that deals with sexual offenses. And really a skeleton statement should first be taken when a incident has happened quite recently and you decide as a complainant that you actually do want to report it. So it happened like 24 hours ago. A skeleton statement should first be taken, and then the victim or the complainant should go to the hospital as soon as reasonably possible, between 24 and 72 hours. That is advisable, right? What we do tell complainants, and these are just some tips if you do decide to lay a charge, is that the police do not automatically provide you a copy of your statement. So it is advisable to take photographs of your statement, right? You'll then be transported to a healthcare facility, and some of them we call TCCs. So they are rape care crisis centers. And here is really where the center has police officers, doctors, nurses, victim support volunteers, and social workers. And really, the model is an integrated team assisting rape complainants, so that you don't have to go from pillar to post every time you need to go to the police or having to go to the healthcare professional. So TCCs at a medical center has all of these facilities and all of these specialized team to assist you in reporting as well.
I think that's very important. I mean, we have seen often or heard of people's experiences of going to the police and finally, mustering up some courage to defend themselves, and to be met with doubt and be questioned about things that are irrelevant. So what you're sharing is really important, because that means that with this information, I can still stand up for myself and say, well, wait, according to this and this and this, you have to assist me. And I think it's very demoralizing when a victim slash survivor goes to the police and then they, met with that. And so I'm glad you're sharing that, and I hope that's helpful, because the first steps are always the hardest. I mean, the aftermath, even that, but that first step of saying, I've had enough. Yeah. So thank you so much for sharing that. And so does the police have the understanding of, abuse can take place and it maybe happened in 2010 and the person is now, I don't know, say 40 years old, and they finally decide to come forward? Do they have the understanding that this case is too valid? Because if we are asking for some test results, a doctor's letter to confirm that it really happened, is that understanding within the police system?
It's interesting that you ask that question, because we get a lot of cases where women come and say, look, I've reported to the police. And unfortunately, just like in our legislative framework, we have all of these laws set out. You have police national instructions that sets out how to deal with these cases. But we obviously know that sometimes that is not implemented in practice. And the police is there really to investigate cases and to collect evidence, right? Yeah. And so it is important, and that's why there are FCS officers, or there's the FCS unit, which is the Family Violence, Child Protection and Sexual Offences unit, where ideally there should be training available, and there is training available for police officers to be sensitive to these kind of cases. And, we still do unfortunately get stories and narratives where clients come to us and report and say, well, you know what, I experienced secondary victimization, and then we see how we can assist them through the process. But essentially, their mandate is to investigate, and that includes collecting evidence, includes the clinical examination, and what we call a J88 form. And this J88 form is used as evidence in court when a rape kit is taken. And that isn't always the case, because some cases, obviously, like you point out in this instance, women sometimes decide to report after, but that is not the only evidence that can be submitted in a docket, which is the docket is the investigation or the collection of evidence. There are other reports, so they'll have to look at the person that the complainant had first reported the incident to, additional medical, psychological reports that all form part of the investigation process. So it's difficult, because essentially, it is what you can prove in court, but ultimately, whatever evidence is available upon investigation, that is evidence that the investigating officer should pursue.
Thank you for sharing that. I think I'm still a bit skeptical, and I understand.
Understandably so, yeah.
Yeah, because I think the practice and the knowledge that you're sharing is great, makes sense. It means that I have power now as a victim or survivor, as the complainant. But then at the same time, the stories, other people's experiences may demotivate me to even utilize this information. It's not to say that the same thing will happen to me, but it's a difficult one. I think we also need to keep talking about this. But in keeping talking about this, we just need to take a short break, and when we return, we'll continue.
We've got what you need. Service that will make you smile. Lower prices than you've seen in a while at Fairfield Meat Center.
Fairfield Meat Center, the family-owned butcher that offers you a top-class, ultra-modern butchery. Visit our online store and have your meat delivered straight to your door. Or visit us at 339 Voortrekker Road, Parow. Download our app from the Google Play and Apple stores for amazing Fairfield specials at your fingertips.
Fairfield Meat Center, where quality meets best prices.
Concocchio Canal Walk presents Tasty Tuesday Trio. Indulge in 3 pizzas, pastas or salads and get the cheapest item for free. Thursdays you get 20% off your food bill when you treat yourself with any pizza, pasta or salad. T's and C's apply. Kokakio Canal Walk serves awesome pastas, sumptuous salads, and gourmet wood-fired pizzas 7 days a week. The only halal-certified Kokakio in the Western Cape.
Calling all primary schools and child program organizations. Jungle Theatre Company's African Folktales is back from the 23rd to the 25th of June at the Wave Theatre Cafe in Long Street, Cape Town, with 2 special caps aligned production of River of Life and Captain Kwanda's Fantastic Adventures. The themes of the shows are water and ocean conservation. Both productions are followed by exciting interactive post-show workshops. Ticket starts from just 35 Rand. For bookings and more, call or WhatsApp Lunga on 072-908-5160 or email admin@jungletheatre.co.za.
Your friend, new couch and your fridge is full. Wat gaat aan?
I started using Jobs app, an app that sends temp jobs to your phone, no more waiting around, and the money goes straight into your bank account.
Serious, what kind of work?
I've done painting, car cleaning, and even helped in the shop last week. Jobs app sends you jobs that matches your experience, then you decide if you want it.
So chase your eie baas.
Exactly. With Jobs app, I work when I want.
Say no more, I'm downloading that app today.
That's jobsapp.com with a Z. Download it and you can take food from your own fridge.
From the heart of Cape Town to your radio, this is the voice of the Cape on 91.3 FM stereo. In her voice, her story, her power, amplifying the stories that matter.
It's 91.3 FM in her voice. We are speaking about justice for abused women in South Africa. What happens if the abuse has happened over a long period of time or a few years ago, maybe a decade ago, in silence, in secret, and there's no evidence and no physical proof? How does the law support you in this regard? We have on the line with us Andrea-Joy Yankees, who is a junior associate at the Women's Legal Center, helping us understand this topic a bit better. And I hope that the first part of the show has been encouraging. And so, inshallah. Andrea-Joy, when we speak about how the legal system defines and assesses historical abuse, in your experience, how do these types of cases typically unfold in the South African courts?
Thank you so much for that question. And the first point or the starting point would be that sexual offences cases are heard by specialized sexual offences courts. And these courts have specialized components, right? So your magistrates understand violence, are trained on violence. You have a court support system and court preparation officers and infrastructure to ensure that victims are safe, where they enter into a safe room before giving evidence, not having to be re-traumatized or have secondary victimization. And so at the starting point, those courts sit within the regional magistrates court. Mm-hmm. And when I think what's really important to know, just taking it from, there's a lot of other things that obviously happen and processes that happen with police officers. But essentially, once the investigation is concluded, what happens is that the docket, the case information, is then taken to the National Prosecuting Authority to make a decision on whether or not to prosecute. And what we have also seen is that unfortunately there is what we call a lot of attrition. Attrition refers to the discontinuation or the dropout rate of cases at various stages of the criminal justice process. And what happens is that the National Prosecuting Authority or the prosecution has the discretion to decide whether or not to prosecute a case, right, based on the evidence before it. And so it is at the hands of the National Prosecuting Authority to decide whether or not the case will then proceed to trial. Before we even get into the court process, that is the process of how your case makes it from reporting to proceed to trial. And unfortunately, what we have seen, and this is one of the gaps in the system, is that most reported cases do not proceed to trial and are not finalized always. And this is really because there are many legal and valid reasons why cases are discontinued or why cases are issued what we call with a nollie prosecute. Nollie prosecute means the prosecution declines to prosecute. And there are many reasons why this happens. However, there have been some concerns that, a lot of the decisions are considered and made within what we call a very deeply patriarchal system. And we all know about rape myths. Sometimes, people and stakeholders within the criminal justice system do not always believe complainants. And ultimately, the requirement for cases to be brought or to proceed to trial is whether there is a reasonable prospect of successful prosecution. And so it is quite difficult because sometimes when cases are reported, they don't always make it to trial. But these are the kinds of cases that the Women's Legal Center looks at, tries and see how we can mitigate that, how we can get involved, and see how we can assist a complainant through the justice system to ensure that they have access to justice firstly, and that justice is actually realized. And unfortunately, like I always say, it's really good in law, but implementation does not always happen. And so we continue to work with government as civil society to ensure that where there are gaps or there are glitches in the system, that we try and remedy that.
No, I think, thank you for sharing that. That was indeed a mouthful, because you can only imagine what a victim, survivor, or the complainant is going through at the time, and having to get all this information and realizing that they have some sense of power might also be overwhelming. But in speaking about support from the Women's Legal Center, in light of if something happened a few decades ago, and we speak about the evidence, what counts, what doesn't count, what can be collected, and so when there's no physical evidence, what kind of testimony, what kind of documentation, how do you build a strong case where there's no evidence?
I guess my advice would be that it's really based on a case-by-case basis. So it's not, unfortunately, it's not I'll give you this kind of evidence, for example, witness statements, psychological reports, that it really depends on the merits of each case. And so I'm not able to give a cover-all kind of scenario. However, from the Women's Legal Center, I would say that come to our offices. We do give free legal advice and see how we can assist in either to report the case, alternatively, how we can refer clients to specialized organizations like Rape Crisis that deals with rape cases for additional counseling if that is something that the client needs. But ultimately, when you speak about other evidence, you are speaking about, if there is no physical or DNA evidence, you're speaking about witness statements, the complainant's account of the incident, the first report statement the complainant has told about the incident, psychological evaluations or reports to corroborate. So really any corroborating evidence that could aid in the investigation and assist the prosecution in bringing the case before court.
I think it's very important, and I'm hoping that the women who want to report, who know that the perpetrator is still alive and wants justice, that they know that they can get justice, irrespective of evidence or no evidence. And I think that's important. And I think if there's any take-home message from our discussion today, it should be that you still have justice can still be served. And I think that will save many women from feeling like, well, there's nothing I can do because it happened so many years ago. So that thank you so much for sharing that. When we speak about age and legal complexities, how do legal proceedings differ when it's when the survivor is a minor versus an adult?
So really, when we speak about minors, I think one of the most important points is that the Criminal Procedure Act does provide for protective mechanisms, whether you're a minor or even an adult. And some of these protective mechanisms is for in-camera testimony. So the prosecution can apply to have the testimony in camera, specifically for minors. Section 158 of the Criminal Procedure Act speaks to an intermediary, and this is usually in the case where complainants are minors or they have a disability and they cannot always speak for themselves. So just to protect minors in that regard, the Criminal Procedure Act also provides in Section 154(2) and provides for the prohibition on the publication. So you're not allowed to name the complainant. And so there are protective mechanisms put in place to ensure that minors are protected during these proceedings. They are not victimized, because unfortunately it's a very daunting process for minors and for complainants 18 years and older. But ultimately there are specific mechanisms in place to guard against any sort of secondary victimization. For all ages, actually, the prosecution also has court preparation officers, and most prosecutors will make arrangements to meet with the complainant before the trial. There is court support from NGOs as well, and we have Red Crisis that are in court, as well as Mosaic. Mosaic deals with domestic violence as well. So the victim is really assisted by assistant officer in collaboration with a nurse and a social worker to make the necessary arrangements for long-term counseling therapy related to circumstances and make proper referrals as well. So the sexual offences courts actually do have a lot of infrastructure to ensure that there is support for victims and complainants.
Very important. I think in every discussion, and I always highlight this, every woman has said support, 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 and how much that is needed on every part of a woman's journey. And I think in the most painful parts of our journey, support is needed even more, especially if we have to reshare. Explain what happened, where it was, and so on. And it's things that, you think you put behind you, and then you have to sort of sometimes relive it. And it's not the greatest experience. But I'm glad that for minors as well as adults, that there are protections and procedures in place that protects them. When we're speaking about the minor's testimony, I know that they're not taken to the court. So how does their testimony get handled? And is there something specific you would like to highlight for parents or caregivers of minors who might have experienced sexual assault?
Yeah, I think it's important that parents also need to ensure it's on a case-by-case basis, right? So it is important that the child is seen by a social worker to assess what the best way forward is. sometimes we deal with women specifically, and so I'm not always in a position to speak on minors specifically, but what I can say is that it is important that each case is assessed on a case-by-case basis, that you ensure that the criminal justice system is not going to re-traumatize children and minor complainants. However, there are protective mechanisms and support to ensure that they are protected. Mm-hmm. And like you said, it doesn't mean that the minor will not give evidence in court. They'll give evidence through intermediaries, and those kind of mechanisms are in place to protect and guard against secondary victimization. Yeah.
We just need to take a short break, and when we return, we'll continue.
From the heart of Cape Town to your radio, this is the Voice of the Cape on 91.3 FM stereo. In her voice, her story, her power, amplifying the stories that matter.
It's 91.3 FM. We are in conversation with Andrea-Joy Yankees, who is a junior associate at the Women's Legal Center. We're speaking about justice for abused women in South Africa and the power that is in your hands and that you can utilize. And we are always hopeful we love the legality and we love the understanding, but the implementation is indeed very important. But the power is still in your hands and justice will definitely be served. So when we speak about how the justice system handles cases that are essentially one person's word against the other, how do we understand that in terms of the survivor and the accused?
I think it's important, and it's very interesting that you bring this up, because we had a case recently in the Supreme Court of Appeal, the Coco case, that relates to consent, right? And the court really looked at clarifying what consent is. And so it is really important that when the court does look at the evidence, that they take into account the objective facts of the case in order to determine the mental state of the accused. In this case, the accused had said that there was this genuine belief that the complainant had consented, and the complainant had said, no, but I had not consented to sexual intercourse. And I think it's really important that when the court looks at, and these are some of the questions that the Women's Legal Center had raised in the case, is that when you're looking at an accused version, you have to look at what is reasonably possibly true, right? There must be sufficient grounds, because you're talking about, he said, she said cases. So when you speak about consent, we really speak about, is there sufficient grounds to have a genuine belief, and that this genuine belief that the complainant had consented? Because oftentimes when rape cases are evaluated, it always turns on consent, right? So is this genuine belief, does it have an air of reasonableness or an air of plausibility? I guess the great thing about this case is that the court and the Supreme Court of Appeal really made such good statements around consent and what consent is. And when we look at consent, that consent to penetrative sex must be communicated by the complainant to the accused. Things like consent to foreplay does not constitute consent to an act of penetration. The court will then look at the objective facts of a case and then make a determination, because ultimately the accused and the complainant, when it goes to trial, there are differing versions of the events that happened.
I'm just thinking about earlier on, you were saying that, there might be no evidence, but the police would still have to investigate, ask a few questions, ask people around them and so on, the community. And it made me think actually that the police have to do work. Actually, when someone comes to you and they say, this has happened to me, whether you want to believe or not believe, a part of your job is to go to where that person is, get the information and start investigating. And I think if that was what was happening or should be happening, maybe some of our cases would be resolved. Maybe some of, the community rapists would be in jail where they should be, instead of, accusing victims. Just randomly popped up in my head, but I think that stood out for me. The fact that they have to work in order to make this person's life a bit better, a lot safer, because of the person that they're scared of or the people that they're scared of.
I think it's also just important to note on that. You're so right. It is a lot of work. Investigation is a lot of work. And so I'm glad that I'm not the one to do it. I think it's also important, just on police investigation, it's also important to note that complainants also have additional remedies in the law that way these cases are investigated, that there are protections if they do feel unsafe, right? Because you were speaking about safety as well. It is important that to know that they can go and get a protection order if they do feel unsafe during the investigation, and at any point they can get a protection order if there is a abuse and domestic violence specifically. Alternatively, if the complainant and the accused is not in a domestic relationship, they can get a protection order in terms of the Harassment Act. Yeah.
Well, another pro tip that you're sharing that will be useful, because I know that sometimes there are victims who have to go back home to where it happens all the time. Or their religious places of worship or at school. So, I'm just frustrated with the police system. But I think if they put the pedal to the metal and started investigating, things would be a lot better.
And I think it's also important that, as civil society, we work and collaborate with police officers, the National Prosecuting Authority, and we hold them accountable. So if there are cases where there are gaps in the system, and there's an injustice, or complainants have issues, there are platforms to bring it to, and the Women's Legal Center works alongside government in some instances, and in other instances we do hold government accountable, but we try and ensure that within the criminal justice system that complainants' rights are realized ultimately.
We just need to take a short break, and when we return we'll continue.
In her voice, her story, her power, amplifying the stories that matter.
It's 91.3 FM in her voice. We are speaking about justice for abused women in South Africa. We have on the line with us Andrea-Joy Yankees, who is a junior associate at the Women's Legal Center. Andrea, you were speaking about timing, a time before 2018 and thereafter where there is no time limit to it. But how important would you say timing is when it comes to someone being violated and then reporting it, and sort of like what support structures should be in place before the case goes forward?
The what we call the Criminal Law Sexual Offences and Related Matters Amendment Act does specify in Section 59, and now I'm throwing sections at you, but really it says that in criminal proceedings, the court may not draw any inference only from the length of time of any delay between when the incident happened and the reporting thereof. And so it is actually in legislation that no inference can be drawn only by the length of time. And I think sometimes when we speak about delays in reporting, a lot of the times in practice, there is still an inference drawn, but the legislation does speak to a court not drawing such inferences. And I think, as a complainant, my advice would be that if you do experience or you believe that a sexual offense has been committed and there has been an incident, go to a TCC, get a rape kit done, try and, get as much evidence, even if it is that you do not want to lay a criminal charge against a perpetrator or an accused, because evidence is important in a court case. And so, it's difficult because it is on a case-by-case basis, but ultimately evidence is important. It should not deter anyone from bringing or reporting an incident of a sexual violence. Yeah.
Very important. I'm interested to know, for an organization that like yours, the Women's Legal Center, and the many other organizations that deal with sexual assault and violence, what is the most frustrating systematic issues when victims go to report or around sexual assault trials, and how do you advise these survivors to navigate these challenges that come up with the system that is so frustrating?
For me, really, it is the delays in court processes. And these delays take place within the system, and some of them are really valid reasons. Either a magistrate is unavailable, has been called for a part, heard matter. But really, I think what is more frustrating for complainants who come to our offices is really to say, look, I've been here, it's been 5 years, or it's been 3 years. And ultimately, what the Women's Legal Center then does is look at where in the process the case currently is, whether it's investigation, whether it is a trial, and see how we can mitigate and resolve any further delays. And I think the other gap or the other issue really within the system is access to information, right? Access to information and the right to information. And that is why understanding your rights and knowing what happens during the process is so important. Knowing that you can ask for certain things, because that ultimately empowers complainants to know that during this process, look, this is what should be happening and this is not happening. And so I can seek advice, legal advice, counseling from organizations within the system, as well as civil society organizations.
Just lastly, because we are running out of time, are there any legal reforms or changes in the pipeline that aim to make the system more survivor-centered?
I think what is really important is collaboration between civil society currently and government. And as the Women's Legal Center, we are also a part of the National Strategic Plan and Pillar 3, which really looks at violence and how we can better the system. So there are a lot of things happening. There are some cases in the pipeline as well. So I think just look out for those on our social media platforms and on our website.
And if you'd like to leave contact details, social media handles for people to reach out and seek support and guidance from the team.
Okay, that's great. So our contact number is 021-424-5660, and handle is Women's Legal Center. You'll find our socials and they'll pop up.
Thank you so much, Andrea-Joy. It's been a pleasure speaking to you. Until we speak again, have a wonderful day.
Thanks so much, Farida. Have a great day.
Thank you. That was the voice of Andrea-Joy Yankees, a junior associate at the Women's Legal Center, speaking to us about justice for abused women in South Africa. They have shared their details. Should you require more information and more support, you are welcome to reach out to them. It's a safe space for you to navigate all that you have been through. It's 91.3 FM. I'm Farida Rabi and Soki and Sunzi. We'll continue right after this.